You're sitting on a new product, a fresh idea, or a distinct brand name, and the clock is ticking to secure your rights before a competitor does. But staring down the United States Patent and Trademark Office filing systems, the immediate pressure is figuring out which application actually applies to what you've built.
To ensure we navigate this correctly, we're going to methodically address every procedural concern through these sections: the decision, core distinctions, examination standards, costs and duration, required maintenance, and finally, the final verdict.
Section 1. The decision point. Let's step right into the stark reality of this filing choice. You have a product, an idea, or a brand name, and you need to file the correct USPTO protection without wasting money on the wrong process. By the end of this explainer, you will know exactly whether your business needs a trademark, a patent, or both, and why the two never, ever overlap.
Founders face immense pressure to lock down the right legal protection, which leads to some critical questions. Do you need a trademark, a patent, or both for what you're building? What's the actual difference in what each one protects? Your brand name versus your invention? How much does each one cost to file, and how long does the protection actually last? Why would a patent examiner and a trademark examiner look at your application completely differently? What upkeep do you owe the USPTO after you get either one, and when? And finally, if your product has both a unique design and a distinct brand name, do you need to file for both separately?
Section 2. Core distinctions, brand versus invention. Let's establish the hard boundary between these two asset types. A trademark protects the brand identifier, like a name, logo, or slogan that tells buyers who made a product, while a patent protects the invention itself, meaning how it works, what it's made of, or how it looks if it's ornamental, which means these two protections cover completely different things and neither one substitutes for the other.
A trademark cannot protect how something works. A patent cannot protect the name you sell it under. This is an absolute rule. If a competitor copies your invention but uses a completely different brand name, a trademark provides zero protection. Conversely, if a competitor uses your brand name on a completely different product, your patent gives you nothing.
Section 3. Inside the USPTO examination. Moving inside the USPTO, having evaluated these applications as examiners ourselves, we apply completely different frameworks to each type of filing.
Patent examiners and trademark examiners sit in completely separate USPTO cores and apply entirely different legal standards. Patent examiners test for novelty under Section 102 and non-obviousness under Section 103 of the law. Meanwhile, trademark examiners test mainly for likelihood of confusion with existing marks under Section 2D and whether the mark is merely descriptive under Section 2E. This fundamental difference is exactly why the two application processes feel so incredibly different to file. By the way, the exact statutory standards examiners apply to each type of application, plus the complete USPTO fee and maintenance schedules for both protections, are broken down in the full article, which we've linked right in the first comment below.
Section 4. Costs and protection duration. Now, let's deliberately slow down and walk through the procedural numbers and timelines you absolutely must plan for.
USPTO filing fees differ significantly depending on the protection type you seek. A trademark filing runs roughly $250 to $350 per class under the TEAS Plus system. Utility patent filing runs $320 to $800 or more depending on your entity size. A design patent filing runs $220 to $500 or more, again depending on entity size. However, when we look at duration, the rules shift entirely. Utility patents last exactly 20 years from the filing date. Design patents last 15 years from the grant date. Trademarks, on the other hand, can last indefinitely as long as they stay in active use and get properly renewed. So, patents run on a strict, fixed clock, but trademarks do not.
Section 5. Required USPTO maintenance. We need to warn you right now. Securing the initial grant or registration is definitely not the end of the process.
For utility patents, maintenance fees come due strictly at 3.5 years, 7.5 years, and 11.5 years after the grant date. Missing any one of these rigid deadlines will cost you the protection entirely, rendering the patent permanently unenforceable. Trademark owners, however, operate on a very different schedule. You must file Section 8 and Section 9 maintenance documents with the USPTO every 10 years to keep a registration active. And just like with patents, missing this 10-year deadline can cost you your brand protection entirely.
Section 6. The final verdict. Let's bring these two parallel tracks back together to answer that final question regarding products that have both a unique design and a distinct brand. The core takeaway here is that a trademark and a patent protect entirely different things, and you don't just pick one instead of the other. Many businesses, like a pharmaceutical company bringing a new drug compound to market or a consumer tech company launching a new device, end up needing to file for both simultaneously. The patent protects market exclusivity for the invention itself during the patent term, while the trademark protects the long-term brand equity long after that patent expires.
For business owners who are still unsure which protection applies to their specific situation, the full article walks through this decision in much more depth, and you can find it linked in the first comment below. We also invite you to subscribe for ongoing USPTO procedure guidance so you don't have to scramble and search for it each time a deadline approaches. Take a hard look at your own operations right now. Which unfiled asset is leaving your business exposed today?